everybody. Good evening. Brian here. Hope you are doing fantastic. It's been a long day. Been working on all kinds of stuff. Went to working on CE. Have CE coming up on February 1st and 2nd, which none of you on this stream, I'm sure, will get the benefit of as far as taking continuing education classes. But if you're interested in learning some very good and very worthwhile information, we have that available. So just reach out to me and we can put that together. But anyway, I've been busy working on that today. So I am a little beat, hence the backward hat and probably just the lack of energy. Okay, I'm awake. So tonight, this is really, I'm just going to record this as one session because this is all going to be Indiana real estate license law. And as those of you that are studying or teaching or can't even talk, those of you that are in the class know that there's not really a lot of sections of Indiana real estate law. Like with the regular or the national portion of the exam, there's contracts and agency and, all the things that we've been covering over the past 7-8 weeks, whatever it's been that we've been doing this. So tonight's kind of the culmination of that to cover just Indiana real estate specific things. So as I was putting it together, it was difficult for me to come up with a lesson per se. So in previous episodes, previous webinars that we've recorded, what I've done is that I'd have like a little bit of a blurb about a particular topic, and I'd talk about it for 5, 6, 7 minutes, whatever it was. And then we go through about 4 questions and I'd talk through it. Instead of that tonight, what I'm going to do is I have 40 questions, 40 questions that I've broken up into different segments, different pieces, and I'm just going to talk through them and use those as the lessons, if you will, for the different pieces of the Indiana real estate license part of your exam. So again, it's trying to, instead of segmenting them in any way that wouldn't be meaningful, just going to go through them. So there's not going to be any breaks. We're just going to go through it. I mean, if I need to take a break, I will, I guess. But at the end of the day, it's just going through 40 questions. So again, I was thinking about it. I'm not even going to wait for your responses, to be honest. I'm not going to burn through them, of course. I'm not going to go through, okay, here's the answer A, and the next one's the answer C. I'm going to talk about them. But, again, I'm going to treat this one a little different than we've treated the past webinars where waiting for your response and all that. I'm just going to talk through it and use that as the lesson. So kind of combining what we've done. I think that's going to be the best way to handle the Indiana license law part. So that is what the plan is going to be for this one. So I think that's it. Let me get set up here in the back. Give me about 15 seconds or so, and we will get hitting on it. Hello, everybody. Brian Lee here with the AHA Real Estate Exam Prep, hoping that you're doing fantastic. It has been a long day for me, but I have a little bit of energy left, just enough to go through some Indiana-specific license law questions. So if you are a viewer here, just the disclaimer, disclosure, whatever you want to call it, if you are a viewer that is not taking the Indiana license law portion of your exam, this webinar particularly will be probably very useless to you. and that's because every state, all 50 states, have their own unique set of license laws. Now, before you tune out, it might be worthwhile to still listen. I mean, first of all, let's put it this way. You get to hear me, which is just phenomenal, I know, right? But more than that, even though every state is different, I have seen, just generally speaking and anecdotally, that a lot of license law has similarities. So what we talk about in here in this particular webinar will be Indiana specific. So if you're studying for the Illinois or Texas or California state exam or whatever like that, this is not going to help you much. But I think that even still, there might be a few pieces that might jog your memory. That we'll talk about in Indiana law, and you go, you know what? That's not the way we do it in Oklahoma, but I do remember them talking about that, so it might be helpful to, again, just jog your memory. But certainly, I am talking about Indiana license law tonight in this webinar. That's what we're going to go through. So again, just putting out that disclaimer, if you're watching this, do not count on this information to carry over to any state other than in Indiana. And also, I guess I probably should say too, just thinking about this out loud, is that Indiana and all states change their license laws every year to some degree. Usually it's minor changes and all that. Every once in a while, they do make major changes. So for the transparency there, and this is more for future people, this is not for the current viewers, but I am recording this for posterity to use in future episodes. We're recording this in January 2022, just to put a time frame behind it. So I'm going through the license law as it sits today. If you happen to catch this video sometime in the future, I'm projecting into the future here for the future listeners, for the future watchers, for the future Brian C. Lee that's out there, that if you happen to catch this episode and you're watching it and you're 5 years away, license law may have changed. So just be aware of that for the disclaimer too. So anyway, the whole thing that we're going to be doing tonight is going through several questions that you'll very likely see some type or some type of form on your state exam. So just going through the questions and kind of walking through what those would look like. So let's get into that and start looking at some of the questions, and again, just take notes and let's have some fun with Indiana law. So the first question asks, if you are a licensed agent selling your own home, what would you do? So this is, again, you're a licensed agent selling your own home. The first answer is you must list the home with your managing broker. Maybe, but probably not. B, must inform buyers in writing of your ownership interest in the property. I think that's where we're going to be, but let's keep going. C, must inform buyers of your ownership interest only if it is listed with your broker. I don't think that's going to be right at all. D, do nothing. There is no business of your broker, or this is no business of your broker since it is your own property. Now that's interesting. I'm going to go ahead and throw D out too. So the answer here, guys, is in fact B. The reason that it's not A, some people might be compelled to pick A out of these answers here, is that you don't have to list with your managing broker. In fact, you might own property that your managing broker can't list. So for example, you're an agent, you work for XYZ Realty, and XYZ Realty doesn't handle commercial property. And you, the owner of a commercial property, want to list it. You might want to list it with company ABC Realty. So you're not going to list it with managing broker. So you don't have to list with your managing broker. You probably will. So A is one of those things you look at and you go, maybe I should, but you do not have to. You can list with anybody, but you do absolutely have to inform the buyers in writing of your ownership interest in that property. So that is the absolute correct answer on that one. Next question. Which of the following needs to be licensed to sell real estate? So who needs to be licensed to sell real estate? Does a county assessor, the executor of an estate, paid a fee to sell a decedent's home? C, a neighbor helping sell a property in exchange for the use of a timeshare in Florida? Or D, an auctioneer? So what do you think? Again, just going through this, remembering some of the rules that we have here of what this is. In order to practice real estate, and specifically to address this a little bit more clearly, to practice real estate and earn an income, to be paid a fee for this thing. And I can answer C, which I think is going to be your answer here, that there is something being exchanged for this service. County assessors don't have to be licensed. An auctioneer has their own licensure. So again, if we look at the answer, your answer is going to be C here, that a neighbor helping sell a property in exchange for use of a timeshare. So that neighbor is being compensated for this. Now, if you saw a question that said a neighbor was just helping to sell the property and, they're doing it for free, hey, thanks, you're my neighbor, I'm willing to help you out, then that might not be the answer. But because it said in exchange for use of timeshare in this situation, the answer is going to be C. All right, next question. A person is not required to be licensed. They're not required to be licensed if they only receive finder's fees from real estate agents. Well, they can't do that. B, they help rent a friend's house for no fee. Okay, that's where we were talking about this earlier. We're helping a friend sell their house, but there's no fee involved. There's no cost, so be careful of this. C, they are employed as a telemarketer, which I realize that's supposed to be one word. We'll have to fix that. Employed as a telemarketer for a real estate office. D, they only show properties for agents but do not write contracts. So in this case, I think your answer is going to be B. That's exactly right. That you are not required to be licensed when you're helping a friend sell their house, and you're not being charged for it. I'm just helping you, just doing it as a friendly neighbor thing. You are not being paid, so you do not have to be licensed. However, if you're getting a finder's fee from other agents, like a referral fee, you have to be licensed. C, if you're employed as a telemarketer, that means you're calling clients, trying to acquire business. You have to be licensed. And also, item D, they only show properties. You have to be licensed in order to show properties. It's one of the requirements. So the only one in here that does not require a license is that friend that's not getting paid at all. So I would not do it even as a friend, but hey, if you want to do it, then you don't have to have a license. Next question. A broker associate may do which of the following? So we're talking about an associate, somebody that works for a managing broker in the state of Indiana. So a broker associate may do which of the following? Maintain their own escrow/trust account. B, advertise in their own name without the name of the firm. C, maintain a separate office and signage at their home. D, operate only under the oversight of their managing broker. So as I'm reading through here, the broker associate, they can have a trust account. And in some cases, they might need to, but that's one thing. As far as must, I don't know if they have to. Advertise in their own name, they can't do that. They cannot advertise their own name. They have to have the name of the firm. They can maintain a separate office and signage at their home or operate under the oversight. So the answer here is going to be D. They can operate only under the oversight of their managing broker. So the managing broker tells them what they do here. So that is the answer to this one. So again, just making sure that we're paying attention to what they're asking. Next question. Excuse me. If a broker is unable to collect their share of commission from their managing broker, what action can be taken to secure the payment? So you are a broker. You work for a managing broker, and your managing broker is a jerk, and he's not paying you. What can you do? A, file a criminal suit against the managing broker. Well, there's nothing criminal about not getting paid. I mean, you might consider it to be criminal, but it's not a crime to do that. B, file a civil suit against the managing broker. I think that's probably where we're going to be. C, file a claim with the Real Estate Recovery Fund. Well, that's not it, because the Real Estate Recovery Fund protects the public when an agent screws up, so that's not this at all. D, seek out action to freeze the managing broker's escrow account. Well, maybe you could seek out action to freeze the managing broker's account, but it's not the escrow account. And the reason it's not the escrow account is because that money does not belong to the managing broker. The escrow account is for clients, it's for clients' money. So I can't freeze their escrow account. If answer D said the managing broker's business account, that might be an answer. But in this case, I think we were back to that B, the answer B, that we would file a civil suit against the managing broker. So that is what we would do here. Next question. Excuse me. Which is true regarding a managing broker's trust/escrow account? So this is the managing broker now. This is not you as the agent. It's the managing broker. What is allowed here? A, interest-bearing accounts are not allowed. This is probably the most common answer that people ask. In fact, when I teach this class to licensed agents, this is the answer they give, and it is the wrong answer. Escrow accounts can be interest-bearing. Now, there's a rule that says that if it's interest-bearing, the interest has to go to the client, but escrow accounts can be, and in fact, sometimes are interest-bearing. So do not pick this one. It's the most common answer that is picked, and it is the wrong answer. So it is not A. They can be interest-bearing. There's just some rules to how you handle it. B, each branch office must have a separate escrow account. We'll talk about that. C, the licensing agency may inspect another broker's unrespected brokers records regarding these accounts at any time. I think that's going to be our answer. D, a managing broker may have only one escrow account. Well, answer B says each branch office must have a separate escrow account. I would tell you that they can, and they probably will, but answer B says they must have, and that is not true. Each branch office does not have to have one. It is advisable. I would recommend it. It's a good idea. Most brokerage firms that have multiple offices do have separate accounts, but they don't have to. There's not a requirement that they do. The requirement is that they have to have one. That's where answer D comes into this, where it says a managing broker may have only one. The managing broker, the rule, to be specific, is that the managing broker must have at least one. This says they may only have one. Managing broker can have 2, 3, 5, 10, 100 brokerage accounts. Maybe they have separate escrow accounts for each of their offices because they choose it. But the answer D is also wrong because the managing broker may have more than just one. So the answer here is C, that the licensing agency may inspect a broker's record regarding license accounts at any time that they want. Next question. The broker's agent must do which of the following? The broker's agent must do which of the following? Disclose to the seller that the buyer would consider a counteroffer. So we have a buyer's agent. Can they disclose to the seller that the buyer would consider a counteroffer? Maybe. B, verify the financial ability of the buyer to obtain a mortgage loan. Probably maybe want to look at that too. C, disclose to the buyer why the sellers are selling if the agent has such knowledge. This is, I think, where we're going to go with this. I think it's going to be the answer. Obey all instructions of the buyer client regardless of their legality. That should be of, not if, of their legality. So what are we looking at here? Well, I have a problem with A because we're disclosing to the seller something that the buyer might want to keep confidential. So I don't know that I can do that. I might be able to do that if the buyer tells me to do it, but I just don't like A for that reason. B, verify the financial ability of the buyer to obtain a mortgage loan. That is not our job. Our job is not to verify their financial ability. We have our client go to talk to a mortgage person and work through that. But it's not our responsibility to check their financial ability. But C, disclose to the buyer why the sellers are selling if the agent has such knowledge. We absolutely must do this. This would put, since we represent the buyer, we know something about the seller that would put our buyer at an advantage here, possibly. So I'm going to disclose that. So the answer here is C. We're going to disclose to the buyer what we know about the seller because we don't represent the seller. We do not represent them. So I want to put my buyer in the best position possible. And by letting them know what the seller's motivation is or whatever the situation might be, I'm going to disclose that information. All right, next question. An unlicensed staff member in a real estate office may do which of the following? So this is an unlicensed assistant, unlicensed person, somebody that is a receptionist, a secretary, something like that. They are not a licensed person. What can they do? A, list property on behalf of the employing licensee. They cannot list property. You have to be an agent to list property. B, negotiate commissions. They can't negotiate either. C, give the list price and directions to listed properties. This kind of makes sense. D, hold open houses for the managing broker only. They cannot hold open houses. They can participate in an open house. If there's a licensed agent that's at the open house as well, you can have an unlicensed person standing in the front, greeting people, being nice and friendly and cordial, saying, hey, here's a card, here's a cookie, here's some water, stuff like that. But they cannot hold open houses on their own. So the answer here is going to be C. That is the only thing out of this list that an unlicensed person can do, is give the list price and directions to the property. All right. Next question. As an inducement to obtain business, a broker may offer what? So I'm trying to get business. What can I do? A, can I give a rebate to a buyer with the buyer's written approval? I'm not sure. We'll talk about that one. B, pay the seller's closing costs with a disclosure signed by the seller. Not sure about that one either. C, a rebate to the buyer with full written disclosure. Kind of like in this more, and I'll explain why on this one too. D, rebate to anyone if disclosed in writing to all parties. Okay, that one's tough too. So there's a lot of rebates going on here. What a rebate says, just for the disclosure of that, is that all parties have to be made aware of this situation. So here is why I don't like A and B, because in both A and B, I'm only alerting one of the parties of this rebate, and I have to alert all the parties. So I don't like A and B. D sounds like that, doesn't it? A rebate to anyone if disclosed to all parties. But the second part of a rebate is that I can only rebate money to my client. So I can't rebate it to anybody. If I represent the buyer, I can only rebate money back to the buyer. Again, after full disclosure to everybody, but I can only give it to my buyer. I can't rebate any money to the seller. Or I can, if I represent the seller, I can represent to the rebate to the seller, but not the buyer. So the answer here is going to be C. This is what I can do. Rebate to the buyer with full written disclosure. In that case, because that's who I represent. Next question. A licensee can lose his or her license for which of the following? Man, how are you going to lose your license? What are you going to do here? A, allowing funds to be deposited into an interest-bearing escrow account. We already talked about that one already. You can do this. Again, there's some rules. As long as you abide by the rules, you can deposit funds into the interest-bearing account. So I know that's not A. B, paying a commission to an unlicensed person. Okay, I think we have a problem there, because paying a commission to an unlicensed person is illegal. So I think our answer is B, but let's keep going just to make sure. C, acting as a disclosed limited agent in a real estate transaction. There's nothing wrong with that as long as I've got disclosure and the clients are aware of it. I would go on to say that they also have to consent to it, but I think they're trying to imply that here. I'm disclosing it so they're aware of what's going on. So that can probably happen. D, charging a commission rate higher than the real estate commission allows. Well, the answer is definitely not D, because the real estate commission sets no such commission schedule. They don't set any of this. They don't even talk about commission at all in here, other than just to make the disclosure of what it is. They don't say that it has to be X percent or anything. So the answer is definitely not D here, because again, the real estate commission does not set fees. There's no such thing as a set fee. No organization sets fees. A brokerage firm, a managing broker, can set the fee for their office, but none of the MLS services, no trade organization, no licensure, nobody can set a commission fee. So the answer in this case is going to be B. Paying that commission to an unlicensed person that'll put you in some hot water real quick. Next question. In order to make a claim against the Real Estate Recovery Fund, one must do what? Again, I already talked about this, but let's just real quickly talk about the Real Estate Recovery Fund. Remember that this is a fund that is set up to protect the public in instances where a broker or a licensed agent acted inappropriately and the client lost some money. So that's what the Real Estate Recovery Fund is for, is to pay money to the public when they have been aggrieved, when something bad has happened to them as a result of what a licensed agent has done. So the question asks, what must they do in order for that to happen? So A, they choose to go directly to the Real Estate Commission as opposed to filing suit with the claim. That is not part of it. You have to go through filing a claim. You can't just directly go to the Real Estate Commission. You have to file the claim first, or file a suit for the claim first. B, file their claim within 2 years of the event that caused monetary loss due to dishonest delaying by an Indiana licensee. This sounds pretty close, but let's just make sure. C, file suit in a court of law, obtain a judgment, and exhaust all legal remedies. I really like this one. I really like this one a lot. D, have a monetary loss, including attorney fees in excess of $20,000. Okay, well, we're going to throw out D right now, too, for two reasons. First, attorney fees are never are not something that they can recover. They do not get any money for attorney fees. The client may have paid attorney fees, but the real estate commission will not pay any money for attorney fees. They will pay for filing fees and court fees, things like that, but not attorney fees. So that makes this wrong. The second thing that makes this wrong is that the maximum amount of money that the real estate commission will pay in this situation is up to $20,000. So the most they would pay is $20,000. This says in excess, in other words, over $20,000. So it is definitely not D. So we're between B and C here, right? Well, let's look here, and the answer is going to be C. Why is it not B? The reason it's not B is because it has nothing. That 2-year claim has nothing to do here. The rest of that question is accurate, or I'm sorry, that answer is accurate, but they don't have to file the claim within 2 years. That is where it's not accurate on that situation. So B is one of those ones that really stand out and make you think about it for a minute, but there's no requirement of the 2-year time period of the event that caused the monetary loss. So the answer is C, file suit in a court of law, obtain a judgment, and exhaust their legal remedies. Next question. The seller's residential real estate disclosure form. So this is the disclosure form. This is what this is. Again, just to remind you, this is the form that the seller must fill out where they disclose their knowledge about the property. So they're going to say that, they're going to break down all the components of the home, the roof, the water heater, the furnace, all the different pieces, the foundation. And they're going to say that this is defective or it's not defective, or they might say, I don't know. And that's legitimate. I mean, maybe you've never been in your attic. So they're going to ask, is there mold in your attic? Maybe you don't know. I mean, it could be up there. Unless you know for sure, you would check don't know, or you would check yes if it's there. So that's what this disclosure form is. And there's a lot more to it, but that's what this is for. So when do we use that? Or it's saying that the seller's disclosure form is for what? So A, it must be completed by the listing agent or seller. Okay, so I'm not liking this, but we'll get to the reason why. B, must be furnished to the purchaser prior to closing the transaction. I'm not sure that I'm liking a B either, and I'll explain why on that. C, warrants the physical condition of the property at the time of the closing. Again, I don't like that for the same reason I didn't like B. D, must be furnished to and signed by the purchaser prior to acceptance of an offer. This is the answer that I like. So let's look here, and the answer is, in fact, D. The reason I don't like A is that the listing agent does not fill this out. We do not fill this out. If this said must be completed by the seller, and that was all it said, then I'd say A is the right answer. But the fact that it said the listing agent, or any agent does not fill this out. Only the seller fills it out. The reason that I don't like B and C is, and this is why D is the right answer too, is that this disclosure form must be provided to a potential buyer prior to making an offer, prior to going through that. In the case of B and C, they're saying prior to closing the transaction. That means we've already accepted the offer. We're really far into this. So it is definitely not B, because it's due prior to putting in an offer, not closing the property. C says warranty the condition at the time of closing. So again, none of that. B and C did not happen at the beginning of the transaction. Excuse me. So it is not B or C. It is definitely D. It must be furnished to, signed, and by the purchaser prior to acceptance of the offer. So that is the requirement there. Next question. Under license law, the managing broker, A, is responsible for their actions and those of all brokers associated with him or her. I like that one. Let's keep going. B, is not responsible for the actions of their licensee if they maintain errors and omissions insurance. That's hilarious. It is definitely not B. Your errors and omissions insurance does not limit your liability. It might make the insurance company pay for you, but you're still liable. So B is definitely not right. C is responsible for their actions only, with broker associates individually liable. I'm not liking that one, but let's keep going. D, must employ independent contractors only. Again, D is not correct. We can hire. Managing brokers can hire employees. Most of them will hire independent contractors. So the answer here, guys, is going to be A. They are definitely responsible for their own actions as well as anybody that is affiliated with them. That if you are a broker with them, that managing broker is responsible for everything that you do. So A is the answer here. Next question. To become a managing broker. So now you want to start your own gig, have your own company, be the CEO, the big dog, the head cheese, all that kind of good stuff. What must you do? A, have been licensed under a managing broker in any status for the previous 24 months. I'm not liking that one. Any status is not probably good here. B, have been licensed under a managing broker in any status for the previous 12 months. Definitely don't like that because you have to have 24 years of experience. So I'm not liking B either. C, have been licensed for the previous 24 months and completed a managing broker course. Maybe that. I'm liking that one. Let's look at D, though. Have been licensed under a managing broker in active status for the previous 24 months and complete a managing broker course. I like this answer. C is not wrong. C is not wrong. So just be cautious. Don't automatically pick C. But what they're looking for is the best answer. C says have been licensed for the previous 24 months and complete a managing broker course. Well, that's great, but it doesn't say that you were on active status. The key part of this is that you have to be on active status for the previous 24 months. So that is why D is the best answer here, that you've been under a managing broker, you've been on active status for 24 months, and you completed that managing broker course. So the answer here is going to be D. Next question. When a sole proprietor managing broker dies, the affiliated licensee does, or what happens to them? So we have a sole proprietor, meaning that there is only one owner of this thing. They're not multiple owners. This isn't a large, excuse me, not a large business, not a great deal of, excuse me, I'm sorry. Goodness. I have a dry throat for a minute. Sorry about that. So we have, again, that it's a single proprietor or sole proprietor. There's one person that owns this business. What happens? And you are a licensee that works for this person. The managing broker passes. What happens? You would have 180 days to transfer your license to a new employing broker. Absolutely not right. There's nothing that says that. Certainly not 180 days. B, have 90 days to complete businesses that is already contracted for. I'm liking this answer because I think this is where we're going to go. But let's keep looking. C, may continue practicing for no more than 90 days. No, I don't think so. You can't continue to practice. D, this is the other one that trips people up. Have 90 days to complete a current listing, but take on no new business. Some people might choose D. They're looking at B and D, and we're looking at that, but D is not right. The answer is going to be B here. The reason it is not D is that when we have a current listing, this is under contract for sale, but remember that listing was with the managing broker, and that managing broker passed away, so this listing does not exist anymore. However, if the listing had a purchase agreement in effect, which is what B is technically saying, even though it's not overtly saying it, you have business that has already been under contract. So if the listing in D was under contract to sell with a buyer, then that would fall under the answer of B. But in this case, it is not D because a current listing, it goes away when the managing broker passes. So the listing's over. Unless that listing is under contract with to sell with another buyer. In that case, then that is business that has been contracted for, and you have 90 days to finish that. So that is the answer B there. All right, next question. If a property is deemed to be psychologically affected, my wife says that I'm psychologically affected all the time, but that's irrelevant to this conversation. Property is deemed to be psychologically affected. The listing agent has to do what? A, they must disclose this fact and the nature of the affectation. How about that for a word? Affectation to all parties. How does it affect them? I'm not sure about this answer. I don't like this one. B, must disclose this fact to prospective buyers. Again, I'm not sure about this. I don't think so. C, may not intentionally misrepresent a fact in response to a direct question. I am liking that. I think that C is probably our answer here. D, has no obligation one way or the other because psychological affectations are not considered to be physical defects. Not liking that either. Answer is going to be C. The reason it's not A and the reason it's not B is because we don't have to disclose this. That's the whole point of a psychologically affected property. We do not have to disclose this. We can, and if asked, we can address it. But D, I'm sorry. So A and B are out because we don't have to disclose it. D is out because we do have an obligation here, and that is answer C, which is that I may not intentionally misrepresent this fact. Again, I don't have to disclose it, but I can't intentionally misrepresent it either. So that's why D is there, is that I do have an obligation. The answer D says I have none. I do have the obligation. That obligation is do not misrepresent. Again, I don't have to disclose, but I can't misrepresent. So that is why the answer is C. All right. Next set of questions. A person would be required to have a managing broker's license to perform which of the following acts? A person would be required to have a managing broker to perform which of the following acts? A, preparing a competitive market analysis. That is absolutely not true. Anybody, even you right now, being an unlicensed person, could complete a competitive market analysis. Now, I'm probably not going to believe you very much because you might not know what you're doing and you probably don't have all the data, but anybody can perform a competitive market analysis. You look around at your neighbors and, hey, what are you selling for? What are you selling for? I think I'm going to put my home in the market at the same price. Anybody can do this. You don't have to be a managing broker. B, negotiate loans. Managing brokers don't negotiate loans, so this is not it. C, sue a seller that refuses to pay an earned fee. Maybe. D, complete an offer to purchase contract for a buyer. I'm liking this one too. So this one's tough. The answer is, in fact, C, sue a seller that refuses to pay an earned fee. Oh, I see what I got lost in my thought there for a minute. The reason the answer is not D is that you don't have to be a managing broker to complete an offer to purchase. Any licensed person can do that. You don't have to be a managing broker. But C, only a managing broker can sue a seller that refuses to pay the earned fee. So the answer is C on that one. Sorry about that. I zoned out for a second. Are you still with me? Okay, I'm there. I'm back. Next question. When a broker changes firms, which is true. So you're a broker, you work for company A, and now you're going to go work for company B. So which of the following is true? A transfer application must be completed. I think that's what this answer is, but let's keep going and look it up. Keep looking. B, the broker's listings are automatically transferred to the new firm. Automatically. No. They might, but they do not automatically transfer. C, the real estate commission appoints a trustee to oversee the transfer of listings. No, they don't. This is an easy process to talk about, and brokers figure this out. Real estate commission does not get involved. The original managing broker sends the license directly to the new managing broker. That is not true either. The license is handled through the real estate commission. So the answer here is going to be A, that a transfer application must be completed. That's what happens when you change firms. You have to fill out a transfer application fee. So actually, I see you saying ugh. The key part of why D is wrong is that the managing broker does not. The managing broker does not send the license over to anybody. What they do is they release the license. The real estate commission gets that license, and then the real estate commission then sends it to the new broker. So this is not something that happens between managing brokers with regard to the license. The real estate commission does that. So that's why the answer is that. All right. Next question. when acting as a limited agent, so we have the situation where we represent buyer and seller, a licensee has certain limitations as to how they should conduct themselves. Which of the following would be a violation of those limitations? So there's limitations, there's limits that we can do. That's why it's called limited agency. So where would we have violated those limitations? A, giving the buyer information about other homes that have sold in the area. I don't see a problem with that. I'm helping out my buyer. There's nothing wrong with that. B, refusing to tell the buyer why the seller is selling. That's not a problem with that either. I can't tell the buyer why the seller is selling any more than I can tell the seller why the buyer is buying, because in a limited agency, I can't reveal any motivation to either party. So there's nothing wrong with me refusing to do so. C, failing to tell the seller that the buyer would probably pay more than they have offered. Again, this is disclosure. I can't do this. So I'm definitely not using C. Then that leaves us with D, telling the buyer that in your opinion, the property is overpriced and the seller would probably take less. That's where I'm going to have a problem. So I think my answer is in fact D, telling the buyer that in your opinion, the property is overpriced and the seller would probably take less. So that's going to be a problem. So that's going to be the thing where we get in trouble, that we're revealing confidential information. B and C, we are not revealing confidential information, so we're good. And obviously, giving buyers information is not gonna get you into trouble. So D is the answer there. All right. Next question. Which of the following is not true about listing contracts in the state of Indiana? Which of the following is not true about listing contracts in the state of Indiana? A, they must be prepared in duplicate. B, they must show a definitive or definite expiration date. I think that's going to be our answer. We'll get back to that. C, they must not be for a term of more than 12 months. Not true. B, they must be signed by all property owners and the broker. The answer, wait a minute. Whoa. I'm sorry. I misread the question. My bad. This is saying which of the following is not true. That is correct. A, they must be prepared in duplicate. They are not required to be completed. They are not required to be prepared in duplicate. They have to have an expiration date. They can't be for a term of more than 12 months. And they do have to be signed by all property owners and the managing broker. So the answer is A. They do not have to be prepared in duplicate. Sorry, I read that question wrong, but that is the correct answer. A is the correct answer. Next question. In the state of Indiana, net listings are A, not legal. B, require the written consent of all parties. I don't think that we need to involve the buyer on this one. C, must state the maximum fee. I think that's probably our answer. Let's keep going. D, must not allow the broker to net more than the seller. That's not true. That's not true. So the answer here is going to be, in fact, C. It has to state the maximum amount of money that we have. They are legal in Indiana, so it is not A. Some states do not allow this. So again, if you've been listening all this time and you're from another state, some states do not allow net listings. Indiana does, but some of the rules are, in this case, they must state the maximum fee. So that's the answer to that one. Next question. Excuse me. Which of the following is true regarding partnership licenses in Indiana? This is interesting. So you have a partnership, and you have and this partnership is involved in the real estate brokerage or the process or ownership of a real estate broker is what I mean to say. So what are the rules in Indiana? A, at least one of the partners must be a licensed broker. Maybe. B, the partnership license fee is $25. Nope, it's not. It's more than that. C, the partners must be licensed brokers. I'm sorry, all partners must be licensed brokers. I think that's probably it. D, partnership licenses must be renewed annually. That is not correct. Licenses are renewed every 3 years. So the answer is going to be C. All partners must be licensed brokers. That's why A is not right. It's not at least one of them. If the answer A, just out of clarity, if the answer A said at least one of the partners must be licensed and a resident of Indiana, then I would probably pick A, because it does require at least one of the brokers to be a resident of Indiana. But C is still all owners, all partners have to be licensed, but only one of them has to be a resident. So again, A might trick you, but C is the correct answer because all partners have to be licensed and only one of them has to be a resident. All right, next question. The Real Estate Commission is comprised of what? The Real Estate Commission is comprised of 12 district members and 2 at-large members. Well, that's not right because it is a total of 12 members. So in this case, that'd be 14. So A is definitely not right because it's a total of 12. And it's also not right because these are not district members, but still the number 12 is the magic number. And this is 14, so it's definitely not it. B, 9 district members and 3 at-large consumer members. Maybe. I'm liking that answer. C, Ashley, I saw you pop in there. You want to change your answer real quick? C, 12 elected members. Nope, they are not elected. Sorry, it is 12 members, but they are not elected. Sorry. D, 9 appointed district members and 3 elected at-large consumer members. Again, not true. There's no election to be part of this. So C and D are not right because it says elected members. They are appointed. They are all appointed. So D is not right either. Try again, Ashley. I'm sorry. I'm not trying to beat you up, Ashley. But the answer is not D because, again, nobody is elected here. The answer here, in fact, guys, is B. They are 9 district members, 3 at-large consumer members, and they are all appointed. That's why C is not right because it's not elected. And D, they do say the 9 are appointed, but they say that 3 are elected at large, and they are not elected. None of them are elected. They're all appointed. So B is the right answer here. Next question, excuse me. The chairman of the Real Estate Commission is... So you knew the answer, actually. That's good. The chairman of the Real Estate Commission is A, appointed by the governor. Ooh, watch this one. B, appointed by the executive director. Watch this one too. C, elected in the general election. Absolutely not C, because there's no general election for this. D, elected by commission members. What do you think? Yeah, Ashley, it's going to get you, isn't it? It's going to get you because it just did. It is, in fact, D. So this is a key part of this. Make sure you know this. The chairman of the commission, or rather, let me say it this way. In order to be on the commission, they are appointed by the governor. So a lot of you would pick A because the commission members are all appointed by the governor. They are not appointed by the director, and they're not elected in the general election. So B and C are not it. However, D is the correct answer because the chairman, once they've been appointed by the governor, the chairman is elected by the commission members. So it is the all 12 commission members that vote to choose the chairman. The governor does not choose the chairman. The governor chooses who sits on the commission. They choose the members of the commission, but the governor does not appoint who the chairman is. The members choose. They vote on who the chairman is. So this is a tricky question. I'm glad that you chimed in here because I know you've taken the exam. The answer is absolutely D here. It is not A. If the question asked a member of the Real Estate Commission, they would be appointed by the governor. But if it says the chairman, in this case, they are elected by the commission members. To become chairman, they're elected. All right. Next question. For active status licensees to be eligible for renewal, so you're an active licensee and you want to renew your license, which of the following is true regarding your continuing education? A, must complete 12 hours of CE annually. I think this is probably our answer, but let's keep going. B, must complete 16 hours of CE annually. This is not right. I don't know that any of you ever experienced this, but back in the day, and again, I'm showing my age here, but back prior to 2012, so 10 years ago, as of this day, 10 years ago, our requirement used to be 16 hours, but 16 hours was due every 2 years. So this would be the wrong answer anyway, but just making it clear, I do have some students on occasion that have taken or was licensed back maybe 10 plus years ago. And you think back, you say, well, back then it was 16 hours, which that is correct back then. But even more so, this answer, I mean, it's not right because it's not 16 hours anymore, but also even when it was 16 hours for 2 years, not just 1 year. So B would be wrong anyway. C, must complete 12 hours of CE each license year. Maybe, so I'm caught between A and C. D, must complete 36 hours of CE every 3 years. So here is the challenge. Here's the challenge with this question. We have to pick the best answer. So C is definitely not right. C is not right because it is not 12 hours of CE each license year. A license year would be make sure I'm reading this right. I think what they're trying to say there is that it's 12 hours each license cycle. I think that's probably, this might be a typo in the question. Let me see what the answer is. It is that. Must complete 12 hours. Oh, I know why. I'm sorry. That's why I read it wrong. I was thinking the answer was A, but answer A says you must only complete 12 hours. It's saying that it must complete 12 hours of CE annually. That is not correct. You need to have 12 hours each year for 3 years. So that's why C is correct. I see what they're asking now, or what they're saying now, is that C is must complete 12 hours of CE each license year. That is correct. I'm sorry on that. I misread misreading the answers there. Must complete 12 hours of CE each license year. So that is absolutely correct. That's what that is. All right, next question. Under Indiana license law, who is required to maintain trust/escrow account? So who is required to maintain this? We went over this earlier this evening, but let's just look at it. A, all brokers. Nope. Not all brokers have to. This is saying who is required to. All brokers are not required to. All brokers can, but they don't have to. It got me too, Sarah. I had to read it twice. So there you go. We're all in on the same page on that one. B, listing brokers. Again, they can, but they're not required to. Again, that's just be one type of broker. C, managing brokers. I think everybody's going to pick C here. I think you know that's the answer. D, managing brokers and licensees who incorporate. No, the answer is going to be C. Managing brokers have to have a trust account. All right. Next question. What action should be taken by a listing broker with earnest money received in connection with the real estate transaction? So you're the listing broker. You have earnest money. What do you do with it? What do you do with it? This is also tricky. A lot of licensed agents get this wrong. So don't beat yourself up if you get this one wrong, although it's going to hurt you more because you need to pass the exam. A, deposit the money as soon as it's received in the broker's trust account. Maybe. B, deposit the money in the managing broker's escrow account within 2 banking days after acceptance of the offer. This is the answer most people choose. This is the answer that most licensed people choose. And it is the answer that is wrong. And I will explain why here in a minute. C, deposit the money in the managing broker's escrow account within 2 banking days after receipt of the earnest money. This is the answer, guys. D, deposit the earnest money in the managing broker's trust account within 48 hours after presentation of the offer to purchase. So I just told you the answer is C. Wrong. The reason that answer A is not right, because you do have 48 business hours, 2 business days to deposit this once you receive it. So it's not as soon as it's received. You do have 2 business days. So A is out. B is the most common answer that people choose, and it is wrong. It is not within 2 banking days after acceptance of the offer, because in Indiana, the buyer and seller get to decide when the earnest money is being delivered. I would tell you, as a matter of practice, it is commonly 2 business days. So it is reasonable and probably very common that that's what we'll do, but it is not required that it is delivered within 2 banking days. It could be 2 weeks, it could be 1 week, it could be 1 day. The buyer and seller decide when this earnest money will be delivered. So that is why C is the answer here, because whenever that earnest money is to be delivered, and when I receive it as the managing broker, once I get it, that is when that 2 business day countdown starts. Not when the acceptance or the offer is accepted, but rather after the receipt of that earnest money. All right, next question. In order to obtain a broker license in the state of Indiana, which of the following is true? In order to obtain a broker's license in the state of Indiana, which of the following is true? A, the applicant must be at least 18 years old. Maybe. B, applicant must be 18 years of age 18 years old or have a high school diploma or GED. Don't think that one's true. C, applicants must have passed the state exam with a score of at least 70%. That is not true. Many of you already know that's not true. It's 75%. D, after successfully passing the state exam, applicants must send the necessary form to the commission within 90 days. That is not true. It's within 1 year, or if you wanted to count days, 365 days. So it is not D because it's 365 days. It is not C because it's 70%. It is not B because you have to be 18 years old and have a high school diploma. So it's not or, it's and. So the answer is A. You have to be at least 18 years old. Now, if A said be 18 years old and have a high school diploma, then that also would be true. But B is not right because it's not an either or. It's you have to have both. So watch for that one. Next question. Which of the following is true of non-resident licensees? So this is somebody that does not live in Indiana, but has an Indiana license. So they live in Florida, they live in Ohio, they live any place other than Indiana, but they have an Indiana license. So what do we have here? A, non-residents may only be brokers or managing brokers. That is absolutely not true. And that is this answer or this question is true of all 50 states. So as I mentioned earlier, most of what we talk about in here is Indiana law, but this is true of all 50 states. Every state law has this, that you can only be a managing broker in the state in which you reside only. That is true of all 50 states. So this answer is an Indiana-specific question, but it's true of all 50. You can only be managing broker in one state, and that's the state where you reside. So it is not A. B, for non-resident licensee or non-resident to be licensed, they must be a managing broker. Well, I just threw that one out, so B is wrong. C, non-resident licensees cannot be managing brokers. That would be true. D, Indiana does not allow non-resident licensees. That is not true. Indiana does allow people living in other states to have the license. So the answer here is going to be C, that non-resident licensees cannot be managing brokers. Only a resident of Indiana can be a managing broker. Other people can be a broker. So again, that's why D is not correct. Jen, I see that you picked D. Indiana does allow non-residents to have a license. They just can't be a managing broker in the state of Indiana. All right, next question. An Indiana licensee is representing 2 buyers. Okay, they're representing 2 buyers. Buyer 1 has seen and is interested in 1755 Maple Street. Now buyer 2 wants to see the same property. So buyer 1 saw and they're interested. But again, I'm not reading into this because I'm going to assume here in a minute that they haven't put an offer in, but that might cause some concern. So I've seen it and I'm interested, but I haven't done anything about it yet. Buyer 2 wants to see it. What can we do? A, may not represent 2 buyers for the same property without the written consent of both buyers. That is absolutely not true. I do not have to disclose that at all. I'm representing 2 buyers, and if they're both interested, great, it doesn't matter. I'm going to represent them both individually, and I can do that. B, would become a limited agent if they show the property to buyer 2. That's not what limited agency is. Limited agency is where you represent the buyer and seller in the same transaction. Representing two buyers that are interested in a property putting an offer, that is not limited agency, so that is not B. C, may only show the property to buyer 2 with full disclosure of buyer 1. No. D, may show the property to buyer 2 without disclosing this to buyer 1. That is absolutely the answer. And we've done this before. This has happened in our office. In fact, Sarah, you might chime in. This may have happened for you. I know this happened in our office before, where we've had two buyers that we represented that were interested in the same property, and we show it. I might say, just as a matter of professional courtesy, that there are other interested parties, but I don't have to tell them that. And certainly I don't have to tell them that I represent all the buyers in this situation. So the answer is, in fact, D. Show the property, and I don't disclose anything. All right, next question. Which of the following would be a violation of license law? Which of the following would be a violation of license law? A, offering a free home warranty to home buyers and disclosing that to all parties in the transaction. I don't think that's a violation. We'll see, though. I don't see anything wrong there. B, acting as broker and disclosed principal in a transaction. I'm acting as a broker and I'm disclosing all this. I don't think I see a problem here, but let's keep going. C, acting as an agent. Right? I see that, Sarah. You're lucky it didn't happen. Well, you're just so busy, Sarah. I mean, with so many people working, I thought maybe you did. Sarah's a rock star. C, acting as agent for both buyer and seller in the same transaction with the verbal consent of both. Ooh. I'm not liking C. We'll get into that why, but hopefully you're already piecing together why C doesn't really look good here. D, offering part of the listing commission to cooperating brokers. We do this every single day, so D is absolutely not right. So we threw out A. We weren't really sure about B, but I don't think I like B. I definitely don't like D, so I'm going to look here, and the answer is C. Why didn't I like C? Why did I not like C? The reason I don't like C is because it says verbal consent. I have to have this in writing. I have to have this in writing. I must absolutely have this in writing. So the verbal consent does not work here. Acting for buyer and seller in the same transaction is not a problem as long as I disclose it and I get it in writing. Verbal consent is not good, or we cannot do that. So that would be a violation. So verbal is not good. Writing is what we need to do. That's exactly right, Ashley. Has to have the written consent. You got it, Ashley. Stop beating yourself up, lady. All right, next question. Which of the following would be a violation of license law? Which of the following would be a violation of license law? A, to give an opinion of value that a seller relies upon. That's not a violation. I'm giving you opinion. I think your home's worth $200,000. And the seller says, okay, I trust you. Nothing wrong with that. B, complete a sales contract for a purchaser. Again, we do this every single day. It's not a violation of license law. C, to act as a limited agent in a real estate transaction. Again, we do this. We don't do it in our office, but you can do this. So that's possible. D, to assure a buyer that a property will go up in value. Okay, let's forget about being a violation. That's just stupid. I'm sorry. If I tell a buyer, hey, your property values are going to go up and it's never going to be a problem, go back to 2008 and remember that conversation again. You're going to say, oh, yeah, I probably shouldn't have said that. I may say, hey, it looks like property values are doing well and they might go up, but I'm not going to assure a buyer that they're going to go up in value. So that would be the violation, and also just plain dumb. So don't do that. All right. Next question. The commission may summarily suspend. Ooh, let's see if you guys remember what that means. The commission may summarily suspend a practitioner's license if there is clear and immediate danger to the public's health and safety for a period of how long? First of all, let's make sure that you know what summarily suspend means. If you remember from class, summarily suspend means that you are effectively thought to be guilty. We haven't had a hearing yet, but we're going to suspend your license on day one because we feel that you represent a clear and immediate danger to the public. And because of that, we're suspending you immediately. And then we will have a hearing after the fact to decide, whether you were actually guilty or not. So it's not that you're guilty. in this situation, but we feel that there's enough evidence that we're going to suspend you now so you do not continue to practice. Then we'll have a hearing. So that's where the question leads to, is that how long can they do this? A, they may not suspend the license without a proper hearing. Well, they can. I just explained it. If they feel you are in immediate danger to the public, then they will and can suspend this even without the hearing. B, they cannot do this for more than 90 days. I think that might be our answer, guys. C, not more than 1 year. That is not true. And not more than 120 years. That is not true. The answer is, in fact, B. They can only summarily suspend your license. They can do this. They can suspend it for a term of 90 days. They have to have a hearing within that 90 days. If they do not, then they have to give you back your license. Now, again, I've never heard of them not doing this, but still, they have 90 days to get that done. Next question. Should a licensee wish to purchase property from a private owner? The licensee must do what? So I want to purchase a home from an owner, from somebody that's selling their home on their own. What am I required to do? A, required to disclose the licensee's true estimate of market value. I don't disclose that. You can come up with your own number, seller. I know what it is, or I have an idea of what it is. I don't have to disclose anything. B, must try to market the property prior to making an offer. I don't have to try to market the property. It's not my client. This is a private owner selling their home on their own. I don't have to try to market it. They're marketing it themselves. C, required to disclose that they're a licensed agent. I think this is our answer. I think you all already know this, but C, we're required to disclose this. D, must tell the seller if the property appears underpriced. Again, don't have to tell you. You're selling this home on your own. Nobody represents you. You want to do it on your own. Have at it. This is the reason why you shouldn't be doing it, but you did. It's what you chose to do. So the answer is definitely going to be C here. Required to disclose that they are a licensed agent. So that is the answer. All right, next question. The commission, upon receipt of a court order establishing that a licensee is delinquent on child support payments, what happens in that situation? So again, we have a licensed agent. They haven't paid their child support, and the commission is made aware of this situation. What does the commission do? A, shall suspend the license and may fine them an amount equal to the outstanding balance. Well, the first part of that is true, but the second part of that is not. The Real Estate Commission doesn't fine them for that. The courts might, but the Real Estate Commission would not do it. So it's not A. B, may temporarily suspend the license until the outstanding balance has been paid in full. It's probably our answer, but let's keep going. C, may place the licensee on probation until the balance is brought current. Oh, maybe. Let's get back to that one. D, shall take no action, as this is under the Attorney General's jurisdiction. That is absolutely not true. The Real Estate Commission will do something. So here we have answer B and answer C. The primary difference here is that they're saying that they are going to suspend your license or place your license on probation. Sorry, Ashley. The answer is actually B. They're going to suspend your license. They do not put it on probation. They suspend your license until your outstanding balance has been paid in full. So C is not the answer. You're not put on probation. Your license is suspended. Pay your child support. And this is also true, just for whatever it's worth to you. If you owe income tax to the state or property tax to the state, and it's delinquent. So this is true not just of child support. This is property tax and also income tax to the state. If you owe that money, the Real Estate Commission will suspend your license until you get caught up, and then they'll put it back to active. All right, next question. Once a broker candidate has successfully completed the state examination, the person must submit their application for a license within what time period? So you completed the class. Yay. Good job, guys. You completed the state examination. Yes, that's what you're going to do. You're going to do it. You're going to knock it out. Everybody on here, you're going to knock it out. So then once you've done that, how long do you have to turn your application? A, there is no time limit once the exam has been passed. There is a time limit. B, within 1 year of passing the pre-licensing course and exam. Maybe, but probably not. C, within 1 year of passing the examination. I think that might be our answer. D, once they have found a managing broker who will hold their license. That's not true. You have to turn your application within a time period. The answer is C. The reason that it is not B, is because it's not within 1 year of passing the pre-licensing course and exam. It is within, or let me restate it this way. Let me say it this way. When you pass the class, when you pass your pre-licensing course, you have 1 year when you graduate to pass the state exam. So that's the first year. After you pass the state exam, then you have 1 more year to turn your application. So that is why B is not correct, because it's not within 1 year of passing the pre-license course and the exam. There is something in there that has some familiarity and a little bit of truth, but it's not accurate, because it would be 1 year of passing the pre-licensing course to pass the exam, and then 1 year of passing the exam, which is why C is the answer, is that it's within 1 year of passing the examination. It is very tricky, actually. And you say it's simple, but your eyes cross. My eyes cross too, especially today. So don't beat yourself up. Next question. When a licensee is convicted of a crime that has a direct bearing on the licensee's ability to practice competently, Indiana license law allows the commission to what? What can they do? So again, you've been convicted of a crime. And to be clear here, just so that I don't know if you'll see this, if you have been charged with a crime, somebody says that I think that you did this, you don't have to report anything. This is, you have been convicted. You have been found guilty. That's what this is. Again, being alleged to have convicted, to have committed a crime. You're being charged with a crime. You're in the process of going through the court hearings and things like that. Until you are convicted, that's when this comes into play. So you've been found convicted. Indiana law allows the commission to what? A, immediately revoke the license. Nope. B, require the licensee to attend a hearing on the matter. I think that might be what it is. C, summarily suspend the license. Probably not. Maybe, but probably not. D, revoke the licensee's membership of the National Association of Realtors. The answer is absolutely not D either. So it's not A. It's not A because they will not immediately revoke the license. They have to have a hearing. So even though the person has been convicted of a crime, the Real Estate Commission still has to have a hearing to revoke a license. So A is absolutely. Sorry, actually, I just saw your answer. Thank you. Let me get back to that. A is not right because it's not immediate. If it says have a hearing and then revoke the license, that might be true, but immediately revoke is absolutely not correct. B is the correct answer here, guys. B is the correct answer. They require the licensee to attend the hearing. C, summarily suspend. They might, but again, it's going to depend upon the hearing and what they go through. D, I want to address specifically. To be clear on this, some people miss this on the exam or misinterpret or misunderstand the process. The Real Estate Commission has nothing to do with the National Association of Realtors. Of course, as professional organizations, they communicate and they work together in some way, shapes, or forms as far as sharing information back and forth. Hey, we found this person in violation of a license law, so we're going to let the National Association of Realtors know. Or maybe it's the realtor organization that tells the Real Estate Commission of this thing. So they do share information, but the Real Estate Commission has no authority to do anything with the National Association of Realtors. So anytime you're seeing these state law questions, I don't want to say every time you see realtor that it doesn't apply. It might, but 99.999% of the time, the Realtor Association is not going to be the answer, or at least it's not going to be the correct thing that the commission would do because they are not connected to each other. So the answer here is B. They're going to require the licensee to attend a hearing and then decide what happens. And then, Ashley, I see that you put allegedly on the test. So again, make sure you're reading your question correctly. If This says when a licensee is alleged to have committed a crime, then it wouldn't be any of these. It wouldn't be any of them in that case. So make sure you're watching it. All right, next question. Which of the following would be true regarding Indiana limited agents and psychologically affected properties? I was just reading your statement, Ashley. I think this is chapter 15 in the workbook. Don't hold me to it. Okay. I have to see what that is. Getting back to the question, which of the following would be true regarding Indiana limited agents? So we have an agent that represents buyer and seller, and now we're throwing in another thing, psychologically affected properties. Let's test your brain on this one, because we have two things going on, limited agency and a psychologically affected property. A, limited agents must disclose their knowledge of psychological affectations to all parties. Not sure. B, due to their limited agency position, limited agents cannot discuss physical affectations. Not sure about that either. C, licensees cannot act as limited agents when the property is psychologically affected. Probably not. D, limited agents, when asked, must not intentionally misrepresent the facts. This is the answer, guys. The answer is D. Limited agency does not, let me say it again, limited agency does not impact the rules of psychologically affected properties. The seller is not required to disclose it. The seller's not required to disclose it. So even in limited agency, the buyer's agent that also represents the seller is not required to disclose it. However, as D indicates, if you're asked, you cannot intentionally misrepresent the facts. So that is where we're at with this. All right. Next question. Indiana advertising regulations would be violated. So we have advertising regulations. They would be violated if a licensee did what? A, places an advertisement for a listed property under her managing broker's name, but fails to include her own. Not sure about that. B, places an ad for real property services that includes only her name, license number, and phone number. That might be a problem. We'll talk about that. C, places an advertisement for real property services that fails to disclose the fees associated with those services. There's nothing wrong with that. We don't have to disclose our fees. You can. Some people do. But there's a requirement that we disclose it, so that's not it. Does not place a for sale sign on a listed property. Some people might pick D here. It is not D. Some sellers will tell us, I don't want a for sale sign, so we do not have to. If our contract says we will, then we should, but in this case, it's not the right answer. So I'm seeing that a couple of you picked B, and I agree. You have to have, if you're an agent, you have to have your managing broker's information on there too. If you're only putting your name, license number, and phone number on this, then that is a violation. So that's the problem here. A was fine because you're putting it under the managing broker's name. You don't have to put your name on it. I mean, you probably want to. You have to have the managing broker's name on it. That is required. So that's why B is wrong. All right, next question. A licensee may represent and be associated with two managing brokers in one state under which of the following circumstances? Oh, wow. You should already know this answer. But let's just go through it because I want to make this clear. A lot of people miss these questions, miss this type of question because they confuse this a little bit. So a licensee may represent and be associated with two managing brokers in one state under which of the following circumstances? A, under no circumstances. That is the answer. Correct. B, with the permission of the office manager. Hey, kids, can I go out and shoot somebody in the face? Yeah, Dad, go do it. I'm going to get in trouble, right? It doesn't matter who gives me permission. I can't do it. C, with the express written consent of the two managing brokers being represented? Nope. D, with the written consent of the commissioner? Nope, because the commissioner won't. The answer is absolutely under no circumstances. You can only work with one managing broker in every state that you work in. Only one per state. However, if you see a question that's similar to this one, that says that you're licensed in 2 states. Can you work for 2 managing brokers? Yes, you can, because you're going to work for one in one state and you're going to work for one in the other state. So you could work for 2 managing brokers, but they cannot be in the same state. So make sure you are clear on that, how that works. You could have a license in all 50 states. That means that you will have 50 managing brokers. Or it could even be that maybe you're the managing broker in one of them. We live in Indiana. So, I would have 49. I'll just put it this way. I am a managing broker in Indiana. If I had a license in all the other 49 states, I would be the managing broker in Indiana, and I would be working for a managing broker with the other 49 states. So there would be 49 brokers that or managing brokers that I work for, and then in the state that I reside, I'm that. Or, again, maybe I don't work for myself. I work for 50 managing brokers. But again, they're all in each individual state. So make sure you keep that process in your head. Because I actually just said it. You will likely see that kind of a question. All right. Woo. That was 40 questions, guys. Your state exam, the state portion of the state exam is 50. I'm not saying we covered all 50 of the questions you're going to see, but that was a lot. That was a lot. I hope that it helped you. Certainly, we covered all the different topics, all the different things that we got into. So I tried to have a blend of everything. Certainly, I didn't cover everything. Those of you that are students of mine, I have an exam guide for you. The AHA people that are out there that are not students of mine, we're working on this for you. If you're in the state of Indiana, I will make this available to you. But if you're a student of mine, you already got it. So you got the hookup. Hey, when you're with me, I got your back. You're not with me? Out. No, I'm just kidding. It's not like that. I will get your back. But again, if you're in the state of Indiana, I have this for you. If you're in another state, we are working on other states. So just right now, we've been focusing on the state of Indiana. That's where we reside. This is brand new for us here in the first part of 2022. So we will be expanding more and throwing that out there and having more states and looking forward to having more of you be able to partake in these type of webinars. So hopefully you will enjoy that. So that is it for me tonight, guys. So we are signing off. Thanks for listening. Take care and have a legendary night. Okay, so that is it for tonight. Like I said, normally we've been having 5 sessions. This just made sense just to kind of burn through it. So I got all that done. I don't have the dates yet, but this is the last of the webinars that we're going to do for a little bit. We will be back in February. So for those of you that have been listening, thank you. Thank you so much for joining us over the past 7 weeks or whatever. We've collected now, I think, right at like 65, 70 videos, something like that. So we have just a ton of videos that we're going to be editing and posting out there. Those will be coming out on YouTube. In fact, actually, if you've been watching YouTube, our YouTube channel, we've been adding videos. So if you've been paying attention, we haven't been advertising it, but they are slowly going out. So be watching for them. And we'll have more. And then I see all the, yeah, that's right. Go Hoosiers. Hoosiers. Anyway, in February, Sarah and I will be back. So we will email you. I believe that don't hold me to it, but I believe our first session will be February 8th, I think. I'm pretty sure that's accurate. So it's like, say, about three weeks away, something like that. We'll advertise it. We will get it out there. You'll know about it, but just know that we're done for a little bit. I'm with love and respect, I'm exhausted. So looking forward to doing more of that with you heading into February. So again, thank you. Take care, guys. I really appreciate it. Reach out to me if I can help you with anything. You can reach me. You guys know how to get to me. All that. So be good. Good luck on your state exams, and we will be in touch soon. Take care.